Let us begin. Thank you very much for joining our mostly daily webinar on child custody and child maintenance. Unfortunately, I cannot in advance advise you at what time I will be streaming live due to obviously other work issues. Many times I have to be in court in the morning or consult, but usually I'll try to have these webinars before 10, before the High Court starts, or before I can start my official day. If you are joining us, welcome. Please note, this is a live Q&A where you pose questions live on Facebook Live and I will try my best to answer them. Questions should relate to child custody and child maintenance. For example, I'm being refused contact to my child, what can I do? Or the other party does not pay any child maintenance, what can I do? Along those lines, those are, I would say, the most simplistic type of questions. You are welcome to pose more complicated and in-depth questions regarding child custody and child maintenance. Please note, as I mentioned earlier on, it is live, so if you do watch this video on another time other than 9:30 tomorrow or on the YouTube channel, I would not be able to answer any questions being posed. I can only answer questions live. If you want to receive reminders in the future, please like the Advocate Muhammad Abduroaf Facebook page. That's the page where I stream from live. There are other cross-posted pages like the Our Lawyer, Private Legal, and so on. Those specific pages are not being looked at whilst I am streaming live. If you can look at on my right-hand side, that's what I'm looking at now at present. And if there are any questions that do come in, I will answer them. I have made it small so your name will not appear. No one should be able to see your name. And after you have posed the specific question, I will place it on the screen, copy and paste the question only, and for all the participants to be able to see it, as well as you who has posed it, and we can tackle that question. The idea is to be engaging in the sense of, if you pose a question, I would like to explain to you the legal position and also the practical way of dealing with that specific problem. For example, if somebody does not pay maintenance, for me to tell you that it is a criminal offense not to pay child maintenance in terms of a court order, that would not help you much. That is the law. If I advise you that you must approach the maintenance court, here we're getting somewhere. If I advise you furthermore that you need to complete your maintenance application form, this could possibly happen at the maintenance court, be wary for this, focus on this, or focus on that, that would assist you more. If you come to me and tell me, I have done the following, I have done all of this, but I'm still not getting the required results, we can maybe discuss it, find a solution, and be able to assist you furthermore in getting the desired result which you want. The same regarding child custody. You might advise us, I am being refused contact to my child. The quick answer would be no, that is not in the child's best interest, and you should not be refused unreasonably. That does not help you much. I might then advise you, please try to agree upon a parenting plan with the other parent. This is what a parenting plan entails. This is how it will possibly, pan out. These are the possible outcomes. If the parenting plan process does not work, this is what you can do, and this is what you can expect from the children's court. Alternatively, in the High Court, you might want to appoint legal practitioners and so on to assist you. Therefore, please pose whatever questions you have. We have one live question. I will post it on our question board. Or do I call it the whiteboard? Let's get there. I presume we can all see it. It goes as follows. Morning. Just have a question. For 3 years, my daughter's father paid her school fees. This year, the weekend before creche started, he decided to only pay half of the fees. I cover everything else. Will I have a good case? I earn more than him. Yes, I would say you would have an extremely good case, unless there has been a material change in circumstances regarding the father. There may be a good reason for him paying half. He could have lost his job. has less income, unable to pay. Maybe certain other expenditures have increased. I do not know at this point. But if he has been paying the school fees for the last 3 years and all of a sudden stop paying without any justifiable cause, he can still afford it basically. But he decided only to pay half. You have a very strong case to approach the court for a maintenance order, directing the court to make an order that he should be paying the full amount of school fees. I'm presuming there is no maintenance order in place. If there is a maintenance order in place, then he is committing a criminal offense. And on that basis, you should approach the maintenance court and lay a criminal complaint against him. He has a legal obligation to comply with the order. If there is no order in place, there has obviously been agreement that he pays the school fees, you should still approach the maintenance court. Even if the father is stipulating and saying that he cannot afford to pay that child maintenance or pay the school fees any longer, he says he cannot afford it and therefore he's paying only half, do not just believe what he's saying, put it that way. You would want to know why, why he's saying so. If he says I'm earning less money, then he should be able to disclose to you his bank details showing that. Failing that, he has a right also to refuse to you based upon you requesting that from him informally. Failing that, I would still advise you to go to the maintenance court, even if he is swearing and saying, I cannot afford to pay the maintenance, I have lost my income, things have changed, etc. You need to be satisfied that that is the case. Yes, you are stipulating that you are earning more than him. I appreciate that. But you are paying for a lot of other things as well. Maintenance is not necessarily applicable only if you're earning less than the other party. No. If you are earning more than the other party, all that it basically means that you should contribute a bit more towards a minor child expenditure. I hope that answers that specific question. If you want to add on to it, I see your name, I will comment further. I have an additional question. Let me copy it. Let us get to that question. I'll just mark the questions that might make more sense. Now we have number 2. It goes as follows. I'm in the children's court currently. My wife completed an affidavit stating why I cannot have shared residence. I responded with proof showing her lying. She now filed a replying affidavit and also stated this is a new founding document. Can she do this as she was supposed to respond to my affidavit? On the new affidavit, there are several allegations with no evidence to support. Her belief is that the court will always believe the mother. I will deal with the last comment. The court does not always believe the mother. The court has to believe the evidence that is more probable. That just makes logical sense. If the father's evidence is more probable, more reasonable, makes more sense than the mother's evidence, the court will have to follow the father's evidence, and vice versa. If the mother comes out with a very good case, evidence to support what she's saying, and it cannot be disputed by the other party. On a procedural point of view, this is how affidavits work. You come with your founding affidavit where you stipulate A, B, C, and D. So you stipulate these are specific information, certain type of allegations which you are making with supporting documentation for your case. So I mentioned A, B, C, and D. Then the other party comes with an opposing affidavit. He or she deals with A, B, C, and D, says I admit, I will deny it, might add a few additional comments, but comes with E, F, and G, additional information. He or she does not only deal with A, B, C, and D, he or she deals with that and also adds additional stuff in support of his or her case. Then in reply, the third set of affidavits, you can only deal with E, F, and G, the additional information. You can't now supplement what you had to say in your first set of papers. In other words, getting a second bite at the cake. You had your bite, you had a chance to present your case, in your cake, and you now decided at the end now to supplement your case. You cannot do that. You can only do that with the court's permission, and generally the court would not grant you that permission. And if the court does grant you permission to add additional information, which you should have submitted in your filing paperwork, then obviously the other party, the opposing party, should have an opportunity to deal with that additional information, because he could not deal with it in his opposing papers because it wasn't there. And then you might get a chance to reply to that as well. It will obviously cause the documentation to be very voluminous and exhausting to peruse over, but that is possible. I see no other specific question in that specific comment. I hope that answers that specific question or comment. It's all about evidence. If you do not have supporting documentation to support your case, that is unfortunate to the other party. It's also the duty, or not the duty, it's advisable at least for you to challenge evidence being submitted if there is no supporting documentation or support to that specific allegations. That's very important. Otherwise, the court might just accept it as being the truth. So if the other party is saying, no, this and that happened, but you know it's not true, and the person says, I have WhatsApp messages, I have documentation to support it, but he doesn't come with that specific supporting documentation, then clearly you need to challenge it and bring it to the court's attention and tell the court it's not true. So it puts a lot of doubt onto that, and the court most probably will just disregard it. I hope that answers that specific question. If you have any additional questions, feel free to pose it, and I'll deal with the third question. I have just copy and pasted from Facebook Live. Okay, let's deal with the third one. A bit long, but I'm happy with that. If you can see on my screen, all the questions are on top over here. So do not be afraid to pose a question. No one can, unless you have extremely good eyes and extremely good PC, they can see who you are, but otherwise your comments are basically anonymous on our platform where we are studying it from. Let's read through this question. My husband and I live in George, and his ex-wife and 6-year-old son lives in Brakpan. So the child lives with the ex-wife. In 2020, she was really jealous because we got married and the son wasn't allowed to see his dad, for 10 months. She used COVID as an excuse. In lockdown 5, she met a boyfriend number 5 in 2 years and moved in his house till January while the child was with us in George. When he got back, he had to share a room with his grandfather. So when he went back to his mom, he used to have his own bedroom and playroom, of course, when they were together or when we lived with dad. There is a swimming pool with no net over it, presumably the mother's place. My husband asked that they must cover the pool since the kid can't swim. Today his son sent a video of the pool and said they don't cover it. When he asked the mom, she said he can address the questions to her boyfriend, obviously boyfriend number 5, with the mom. The husband said no because she is the mother. So currently the father of this matter does not want to deal with the boyfriend. She only responded saying he can contact her lawyer. Can she do this? I think that's a question. My husband also pays maintenance for her to buy 1,000 worth of clothing for her every month. She also refuses to send proof what she does with the money, I presume. We don't know what to do anymore. We can afford to always go to lawyers, I presume. They're saying we can't afford to always go to lawyers. This is an extremely difficult thing because we have 2 different parenting styles. I mean, you can't limit somebody from having boyfriends or spouses or being in a relationship. Things don't work out, things continue. I don't think any judge will say that if you're not allowed to do that. That's unfortunate. We expect people to be responsible in their lives. I presume that there is a divorce order, there is a contact and care arrangement in place, and if there is such an order in place, the parties will have to enforce that specific order. Regarding the day-to-day activities of the family, there's a swimming pool at the mother's place. The child could possibly jump in the swimming pool. Those are serious things, and I think it must be addressed in some way or another. I would strongly suggest a specific father to speak to a social worker, address this issue to the social worker, and ask the social worker to please communicate with the mother and advise the mother about these concerns. And ask the social worker maybe to investigate into these specific concerns, why the mother acting this specific way. Alternatively, as the mother said, she has an attorney, get an attorney to write a letter to the mother. These are one of these unfortunate things, because you would expect parents who are separated to act responsibly and maturely. And no court of law, no order of court can make somebody act maturely when it comes to these type of things. And in my view, it's unfortunate because families are supposed to, once families separated and divorced, they're supposed to work in harmony together in relation to the minor child. But that is obviously not the case under these circumstances. So my advice to the specific parent is, firstly, get a social worker on board, speak to the social worker about your concerns. The social worker can obviously address it to the mother and see what the specific outcome there is. Alternatively, if you feel that the mother is a bad, not unreasonable, or she neglects the child, or she places the child in danger, then it might make logical sense for the child to be in your primary care, because when the child is in the mother's primary care, she places the child in danger and so on, and she has a lot of boyfriends which you are not happy with. So those are the options you have. By the end of the day, an expert will have to get on board in this matter, because it's not social welfare issues I'm seeing over here. A mother that has 5 boyfriends, I don't know, I'm not here to judge anybody, but does the court decide based upon the fact that they have 5 boyfriends, or not, they have 2 boyfriends, 1 boyfriend? What is the thing? And if you have 5 boyfriends, automatically does it mean that you cannot have custody rights and so on? If you have a swimming pool, you don't cover the swimming pool. If the child lives with a grandfather, is that a bad thing? So at the same time, if you have a problem with the way the mother is caring for the child and the condition the child is living in, then you need to do something about that. Then maybe you should now decide, okay, then I want primary care of the minor child. So get a social worker on board, write a letter to the other side, see what they have to say, see how they respond. She did say, speak to my lawyer. But if all else fails, then you must make a decision. Am I going to court, or am I now trying to get primary care over the minor child? I hope that answers that specific question. If it did not, please feel free to pose whatever questions you have. So I have an additional comment regarding question 1. So I will just copy it quickly. If there are any additional questions, I'll be happy to answer them. So this is part 2 of question 1. I asked the very first question, thank you for your response. I don't have slips. I throw everything away because I don't see I did not see this coming. Must I wait now and build up slips before going to court for food and clothing, extramural activities, and so on? Yes, you're welcome for the answering the first question, and you're welcome to pose any additional question, as well as question number 2, and number 3. I would say you should have an estimation on how much a child costs. Do not now wait many months to first build up slips and build up proof if you specifically require the child maintenance. If you have the time and you're fine with it, that's up to you. But I would say the challenging amount to work out would be most probably only the grocery bill. I mean, electricity, water, schooling expenditure, other daily activities which a child might incur could be easy to work out, but the grocery bill could be a bit challenging. The accommodation cost can also be easily worked out. You obviously have, I don't know, I presume you paid via card. Many people pay via card these days. If that is the case, you can come to a general amount as to how much food the child eats and so on. So do not necessarily delay the maintenance application for many months because you're trying to build up slips. I think that's a bad idea, because it might take you many months to appear in the maintenance court in the first place. So what I would advise is make the application in a few days' time based upon all the relevant information which you have. You work it out very well. And in this period, while you are waiting for the maintenance court to call upon you or to advise you and the father to appear in the maintenance court for formal maintenance inquiry, which might be in 2-3 months' time, then you would have had at least 2-3 months to prepare all these specific slips and get all the documentation and all the proof. And then you can properly work out everything. But now, based upon your assumption, you come to a certain type of an amount. And when you do approach a maintenance court in 3 months' time, when you appear in the maintenance court in 3 months' time or so, you can tell the maintenance court, when I made the application initially, that was my assumption because of the limited amount of information I had. More than likely, the amounts will be exactly the same, or more than likely it will be more, because based upon your current receipts, which you have built up over the last 3 months. And the maintenance court will obviously be understanding, and that those are the facts. You did not try to lie to the court initially. All that you done was you tried to obtain the relevant information. You tried to make the application, and in the last 3 months you obtained additional information. I hope that answers that specific question to question number 1. I see we have question number 3. I got another comment. I will just add this into the screen. This question number 3 is additional question. Let us see if we can all see it. Yes, we should all be able to see it. Regarding question number 3, my mother, son, and grandfather lives with the boyfriend now. Grandpa looks at bad stuff on the internet. Now the child must share a room with him. Yeah, no, these are difficult things, you know. How do we change people's ways? If this is the way grandfather acts and responds and the child is there, I would say then you need to make a decision. You need to now make a decision. The father needs to make a decision. He says the environment the child is living in, whereby the mother is the son and grandfather, they live with a boyfriend now. Grandfather looks at bad stuff on the internet. I do not know, but it's bad stuff and most probably things which a minor child should not see. This is the type of people we have. That they're most probably wonderful people, but they're not the best for the minor child under these circumstances. You cannot, in my view, change them. You can send them a lawyer's letter. You can get a social worker to contact them. All good ideas. Why not? But if it doesn't do anything, if it doesn't change the circumstances, then the father needs to make a decision and say, I believe it is in a minor child's best interest to reside with me primarily because he or she will be better cared for by me. So that's the long and the short of it. It's like the child living with somebody that doesn't have a TV. They only have one bedroom for 4 children to sleep in. They live far away from a school. The area is a bit dangerous. These are the realities of the situation. No court can change anybody's circumstances, anybody's situation. Many kids, most probably under these circumstances, they survive, they make it through life. Many kids are in a worse position, 100 times worse position. That is a fact. But under these circumstances, when you look at a mom and a dad, where the mom is providing the child with a bad environment as compared to what the father can provide. In a different scenario, in a different area, that might be a fine environment. I do not know. Here the father must make a decision, and he can decide now whether or not to take it to the court, and the court can now decide what's best for the child. Either live with the father or live with the mother. I hope that answers that. You're welcome to pose any additional questions. And those are the 3 questions which you are unpacking. If you have any additional questions, please feel free to pose it, and I will try my best to answer it. Let's get this question a bit further up. Okay, while we're waiting for additional questions to come up, I should be able to see it on my screen on my right-hand side. Child custody issues are very difficult. It's highly complicated because we're dealing with 2 sides. And both sides obviously want what's best for the child, but they have 2 conflicting views as what is best for the child. It's like 2 parents, they're arguing over what school will be best for the child, school A or school B. Both want what's best for the child, but it causes a dispute. Or one parent's view is, no, it's fine for my daughter to wear miniskirts. She's 13 years old. It's fine. Under certain cultures, certain environments, it might be fine. Under the mother's view, no, it's not fine. But the father's view, it's fine. He can see nothing wrong with it. Maybe there is nothing wrong with it. Maybe there is. I'm not here to judge anybody. Where I'm going to with it, when I'm going to with a specific scenario, is that the parties cannot come to an agreement. They are struggling to find out what is best for the minor child. Under those circumstances, it is best for them to see a professional, an expert, and the professional should be able to advise them what is best for the minor child under those specific circumstances. The topic and the theme which I am focusing on for the next few weeks is toughen up. Toughen up in the sense of many people, they approach the maintenance courts, they approach the children's courts, or they deal with those type of issues and type of matters, and they are struggling to mentally deal with them, to deal with it. And by doing so, they decide to abdicate, or they decide to stop the actual court process, the actual maintenance process, because of the apprehension and worrying about certain silly things. For example, oh, the father of my child will be there, I don't want to see him, I have bad memories, therefore let's forget about this whole thing. Or, for example, they go to the domestic violence court, they make an application for a protection order, and then after they have made the application for the protection order, they have to appear at the protection order court, at the domestic violence court. Now they see the ex-spouse, the party against whom they have made the complaint against, and who allegedly committed domestic violence against him or her. They get apprehensive, they become, anxiety comes into them, and now they decide, no, I'm not proceeding anymore, it's fine, I'm withdrawing my application. Or they are underrepresented. Some big lawyer walks to them and saying, I'm representing your ex-husband, your ex-partner, your ex-lover, can we settle this matter? You know, if it goes to court, it will be messy, we'll have to litigate, can be very expensive, blah blah blah. You get scared. I would advise you to toughen up, fight for your case, fight for your rights. Do not be afraid of the system. Own the court, believe it's your court, you made the application, the court is giving you audience to present your case. Do not be afraid of the other party. Do not be afraid of the potential of losing a case. Be reasonable, be rational, and toughen up. Because if you do not toughen up, you will go through this emotions and these issues for a very, very, very long time. I'll come back to the topic shortly. You could see on my screen, it moved a bit. There's another question. Let's see what it is. Okay, we're going back to question number 3. Let me copy that in. Okay. The comment is as follows. Thanks for all the answers. You are welcome. Can dad ask mom for proof of 1,000 and clothing she says she buys monthly? He pays monthly towards the 1,000. Yes, he's welcome to ask. He should ask, and a mother should hopefully provide him with that. If he doesn't want to provide it to him, what can he do? There's not much he can do. He can either, he has a few options. And some might not be better than the other, some might be worse than the other. You can either decide not to pay the 1,000 rand. If there's a court order in place, he cannot do it. So if there's a court order in place stipulating that he should pay 1,000 rand per month towards clothing to the mother, and he presumes the mother does not use the money for the clothing, he might presume she's using it for herself, he cannot stop paying it. I would advise him to continue paying it, and because it's in terms of the court order. But if he believes the mother is not using the money for the child and she does not want to provide proof, and the court order does not stipulate that she has to provide proof, and then he needs to continue paying it. Alternatively, approach a maintenance court and ask the maintenance court for a reduction. I do not think it's a good idea for parents who are separated, who are divorced, and there's a maintenance order in place, to having to continually communicate with each other on a monthly basis. Because now you provide that slips. The other party say, why did you have to buy the socks? It was not necessary. 2 months ago you bought socks as well. Then the primary caregiver who's receiving the maintenance might say, but if the child needed the socks, it just causes major problems and issues at the end of the day. It is better to pay the maintenance if it's reasonable and it's justified, and continue the life and not communicate unnecessarily with the other party. And also the issue concerning requiring proof, unless a court order stipulates otherwise, it is also an issue concerning wanting to control the other party again. So I'm giving you the money, but I'm controlling how the money must be used. Yes, you are not specifically saying how it should be used, but you're saying, I want to see how it's being used. And obviously, if you're not happy on how it is being used, you will query it, and it causes many animosity and many problems going forward. So getting back to the question, yes, you are welcome to ask. If the other party does not want to provide it to you, you have two options. Go to the maintenance court, challenge it, and ask the maintenance court to make an order specifically stipulating that the person must show you what he or she used the money for. Alternatively, if you can move on with your life and just accept it, I'm paying the 1,000 per month. The money must either be used for clothing or the money gets used for food or whatever else for the minor child. Alternatively, the other party is a primary caregiver of the child. This month the child might only require no clothing, but next month the child might require 2,000 rand worth of clothing, for argument's sake. It's very difficult to stipulate that the child will require clothing every single month of 1,000 rand. What if a pair of shoes cost, maybe for example 500 rand, and a jacket costs another 800 rand? So this month the child actually required 1,300 rand worth of clothing as opposed to 1,000 rand per month. So it's hard to say you can only spend 1,000 rand per month. What if an item costs 1,200 rand? You're welcome to ask, but if the party does not want to provide you with the specific answers, you will have to approach the court, and the court will determine, is it necessary for us to have this monthly checking control over the other party. My view is pay the money and move on. The other party will obviously have to know how to use that money, and we trust the other party will use it correctly. But if you want to be involved in other parties' decision making, you need to get a court order to be so involved. Are there any additional questions? There are no additional questions. You are welcome to pose any new questions or any additional questions. All those three questions you are welcome to add, and I will paste it onto the screen and we can take it from there. Now, while I'm waiting for additional questions, concerning the theme which I'm working on the specific months or for the next few weeks would be, as I said earlier on, toughen up. Take ownership of your case. It's your case, and you need to make sure that you get the best success out of your case. Just a reminder, while we're going on, I'm having a live Zoom webinar on Wednesday coming. I don't know if you can see it, maybe on the screen. I need to change the color of that. Make it white. Oops, you can't see anything over there. On Wednesday, my apologies for that. On Wednesday, we're having a live Zoom webinar at 1 o'clock. The nice thing about Zoom webinars are that you are in direct communication with the presenter, myself, and you can directly engage with me on Zoom. You can pose questions and so on, and you can pose a question way in advance. So when you register for our Zoom webinar at telelaw.co.za/register, I will provide you with that link on our other platforms. We should be posting it everywhere. And if you go to Our Lawyer Facebook page, there should be a link with that specific link for the live Zoom webinar for Wednesday at 1 o'clock. You can watch us live. It will be on Zoom. It will also be on Facebook Live as well. But the interaction will be preferred for people who are on Zoom. So it will basically be child custody battles. How do I get the best out of my case? Very important. Many people, they are struggling to deal with child custody matters. How to deal with a child custody case. The matter might be pending in the children's court, in the custody court, and so on. Hold on 1 second. There it is now. There you can see it. Free Zoom webinar, telelaw.co.za/register. Please go to the website and please register for the specific webinar. It will be very useful if you do that. Once you're registered, you will receive an email from us, and the day before the webinar, you should receive the Zoom login details. We are limited, I believe, to 100 people that can join us for that webinar. And you're welcome to pose a question before the time, as opposed to these specific live Facebook Live webinars whereby you have to pose a question on the day. And the webinar gets recorded, and a link should be sent to you by email or via WhatsApp, whereby you can watch the webinar later on as well. But we would have obviously have dealt with a specific question which you have posed, and it's free. So go to telelaw.co.za/register, and on that link when registering. You're welcome to pose a question. If there are no other questions, I think our webinar now came to an end. I will be online again tomorrow. I do not know what Pacific time. It's Monday today, and I thought I'll get this out of the way as soon as possible before I get to my other legal matters. Nonetheless, thank you for joining. Thank you for those 3 participants who have posed those questions. I hope I have answered those specific questions for you, and I hope that through this process we can assist people in resolving their family law matters. If you like this video, please share it. It's always appreciated. I hope you have a wonderful day. Thank you very much.